Hello, everyone, and welcome back to the Trade and Tech podcast brought to you by Gaia Dynamics. I'm Emil Stefanuti, co-founder and CEO of Gaia. And as always, I'm happy to be joined by Tom Gould, Gaia's Chief Strategy and Compliance Officer. Tom, how are you? How are things?
Great, thanks.
We have a great episode today. You know, a lot of people have been asking us about this, and so we've been looking forward to having this conversation. As we await Supreme Court's ruling on tariffs, you know, we'll dive deeper into the different scenarios and expectations and, you know, what's kind of going on and share as much as we can about the expectations of what's coming. And super excited to be joined by a great expert in this field, Cameron Roberts. Welcome, Cameron. It's such a pleasure to have you.
Thank you so much. Thank you for having me today.
Yeah, and I'll do my best to talk about your very impressive trajectory with over 35 years of experience in international trade and transportation law. Very unique and diverse background. Managing partner at Roberts and Kehagiaras. You're a licensed custom broker since 1989. You know, transportation executive areas of expertise include custom law, export compliance, insurance matters, maritime law, and both domestic and international transportation law. Super impressive. And you're an active leader and deeply involved in the trade community. You've served as president of both the Foreign Trade Association and the Harbor Transportation Club, currently serving as an advisor and counsel to the HTC Board of Directors. I was super impressed, you know, that under your guidance, the HTC had raised over $150,000 in scholarship funds for students pursuing careers in logistics, frequent speaker at conferences and events, host of your Logistically Speaking podcast, which, by the way, for our audience, if you haven't checked it out, you should definitely listen to it. And as far as I know, you are admitted to practice in California, Washington, the Court of International Trade, and before the Federal Maritime Commission. Did I miss anything, Cameron?
Oh, did a great job. Thank you. As my family sometimes says, you're a busy guy.
Yeah, you are.
And it's, you know, I think you get back what you put into it. And I've had a lot of great people help me along the way. So I kind of feel that if there's any opportunity that I can work with people and do the same, I think it's important to do that. You know, it's keeping the continuity of, you know, what we know alive and helping people in the next generation, as well as our own clients, stay abreast of what's out there. You know, look at the pitfalls and hopefully avoid them.
Absolutely. And yeah, you are a busy man, and we're extra thankful for you to spend some time with Tom and I. So let's just jump into it. And I'd like to just set the table. I mean, I think in our audience, chances are that everybody's well aware of what's happening, but still, just to make sure that we're all kind of on the same page. Cameron, I'll start with you. Like, for people who haven't followed this closely or closely enough, what exactly is the Supreme Court being asked to decide?
In a nutshell, there are two cases that are before the Supreme Court of the United States. They deal directly with the IEEPA tariffs, and the issue boils down to this. There's a clause in the regulation, in the law, that basically says that the president has the authority. There's been a delegation, if you will, from Congress through it, what the Constitution gave them, been a delegation of authority to regulate imports. What you have to keep in mind is, what does that word regulate mean? And you're going to get into a lot of argument with, you know, scholars, people with a particular point of view about where this is going, how it's going. The easiest examples for people to understand are the fentanyl tariffs, because their first order of business is there, as a precursor to this notion of regulation, is there a national emergency? Now, the president put forth that there is a quote unquote national emergency, fentanyl-based national emergency, and said, this is a reason, this is the emergency, and on this basis, we're going to assess duties against Canada, Mexico, and China. So these are fentanyl-framed duties. And so that's one bucket, if you will. And then the other big bucket is reciprocal, which is there's deemed to be a national emergency, again, not based on fentanyl, but based on really a balance of trade issue. We don't have a proper trading relationship with most of the countries on the planet, because it's really assessed against everyone. So from the president's point of view, the national emergency is sort of, shall we say, putting the balance of trade back at a more equal footing. And in effort to do that, again, has claimed that the IEEPA gives him the authority to do this and that he can regulate that trade. And that's why you see a multitude of trading nations come to the United States and now engaging in some sort of diplomacy, a negotiation, whether it's Korea, whether it's India. And you see isolated incidences as well beyond the reciprocal, strategically identified by the president as being, okay, I don't like this behavior, and therefore under IEEPA, I'm going to assess X. Now, is India's purchase of oil from Russia a national emergency sufficient to justify the additional IEEPA tariffs on India? Like I said, there's very broad examples and there's very targeted and narrow examples, all utilizing IEEPA. And I think that's intentional and strategic on the part of the president to do this, because he is trying to make this, frankly, as punitive as possible if he doesn't get his way, meaning that you're going to have to unravel a lot. And so he has been doubling, tripling, quadrupling down on the IEEPA ever since the beginning, because the moment he did it, there was a legal challenge. And that's what is now before the Supreme Court.
Yeah, I keep hearing about, separation of power implications on this case. And so I guess, why does this case matter beyond trade? What's the big sort of constitutional or separation of power issue here? Is there one, in your opinion? And I just keep reading and hearing about this.
Certainly, Judge Kavanaugh's opinion is what's much more interesting than anything I have to say. But Kavanaugh has repeatedly spoken about this concern over the balance of powers, and several other justices as well. Is it appropriate to delegate the powers that the founders gave to Congress to another branch of the government? In other words, the Constitution sets a framework. And what we've seen is through statute, Congress has altered that balance of power. And I think the court has a longstanding concern about, does this undermine the way our government was designed to work under the Constitution? And you saw that concern being expressed, I think, at length during the oral arguments. There were a lot of discussion about things like, well, if we rule with the executive and we give the executive the authority that they're asking for in this case, how would Congress ever get it back? And the answer is, it would have to, in theory, pass a law that restricts the executive again. And then not only that, what would happen if the president were to veto it? So you'd have to have enough of a majority to override a veto power of the president of the United States. And that's a heavy lift.
Yeah, we'll we'll have to see. I guess, Tom, bringing it down a notch, and I know you're talking to peers and customers all the time, and I'm sure that this is a topic that's being discussed over and over and over. So what are you hearing from your peers and customers? What are the biggest concerns?
Well, I think the biggest concern that I'm hearing about is uncertainty. It's one thing for companies to absorb tariffs if they know about them enough in advance to build them into their business. But the uncertainty really seems to be the bigger concern, because what we've seen happening is tariffs are announced and imposed within hours or days. And there are many, many situations that just about every company can point to where they bought a product. That product was either in the process of being produced or being shipped to the United States. And between the time that they placed the order for the product and the time that the shipment actually arrived in the U.S. and they paid the tariffs, all of a sudden the tariff rate that they were assessed on their products was increased significantly and materially. And companies have a difficult time with that. And it's okay maybe to do it for the short term, to do it once or twice, because then It's something that companies can build in. But because of the uncertainty, what's happening today is companies are building in cost into their product that they may not know, they may not have, right? They don't know what the cost is going to be. One of the things we're starting to hear about is that the tariffs are impacting the cost of living. The price of stuff is going up simply because of the tariffs. And so I've been starting to hear rumors and a little bit in the press about possibility that President Trump will make some changes to the tariffs in the near future that will reduce the amount of tariffs on some products. We don't know what products, we don't know when, we don't know how much, but there's a possibility. And if that happens, again, how long will it take for a company to adjust their pricing to reflect that reduction? So it's that uncertainty that's the biggest question that I'm hearing about these days.
And we see it every day, and we were attending events recently, and it's definitely top of mind for everyone. And sort of diving a little deeper right into the legal core of things here, Cameron, where does the government's argument have real strength? Like, what's the best case for the tariffs under IEEPA?
What's the best case? It depends on who you talk to, I think. When I was talking about this doubling and tripling down, like if you were choosing a course of action and you weren't certain that you could do it as a matter of law, why would you continue to do it over and over and over again? And the answer, I think, is to make it more difficult to unravel, more damaging to the economy, more of a threat, if you will, to the stability of the economy and the country at large. Whether you're talking about our national debt, you're talking about our budgetary process, you're talking about our ability to pay government workers, because we seem to have an endless cycle of government shutdowns because of monetary constraints. So what the president, I think, has done, and what his best case is to go to the court, either directly or indirectly. I think a lot of this has been indirect, and say, if you don't give me the authority to do this, look at the impact it's going to have on the budget. I've collected, over $130 billion of duty. Funding that is going to be complicated. It's going to be time consuming. It's going to be expensive. And it's going to damage the treasury in some fashion, because it may only be 7-8% of the total amount of revenue that the United States government collects, but that's still a lot of money. And some people have argued that we've become addicted to this tariff revenue to facilitate doing certain things and borrowing against it already. So again, hard to unwind that way. Also, in the course of the argument, the government's repeatedly referred to these as not tariff unmodified. It was always as a tool of foreign policy and as a tool of not revenue, but regulation. So they called them either regulatory tariffs or tools of foreign policy. And I think that language choice is important, because it's absolutely clear under the Constitution that the commander-in-chief, president, has authority over foreign policy. And if this is nothing more than a tool of foreign policy with an incidental revenue impact, then maybe the president can do it. So I think that the best case, if you will, from the president's point of view, is making it so abundant in his foreign policy. And it's hard to argue that it hasn't been abundant, because he's used it as a threat against almost anybody and everybody at any given time. And I expect that trend to continue, because he sees tariffs as a foreign policy tool, without doubt. The downside risk is that if he has the authority to do this, and then you start analogizing the word regulation to taxation, then you've given the executive pretty much unlimited authority to tax Americans. That's the slippery slope that I think the justices are worried about. I think that's the slippery slope that we should all be worried about, because being taxed with the stroke of a pen, as Tom says, because the president doesn't like something, creates massive problems for everyday people and every business that imports into this country, which is either directly or indirectly everybody, because from the clothes that we're wearing to the coffee that I was drinking to the device that I'm speaking to you on, all of this was made someplace else, or some part of it was made someplace else. So to think that we are not dependent on the global economy and the global web of, infrastructure that has been built is just simply unrealistic and naive.
Yeah, certainly. That's a very good way of explaining it. Thank you. And let me ask you this, because I mean, we keep hearing, are they gonna rule in favor or against? But is there a middle path? Are there any options in between, like upholding some tariffs but limiting duration, scope, or process? What could be some middle path options? Are there any?
I think there are, but they would create a lot of confusion. So, courts tend to go in a more, it either is or is not constitutional sort of world because it's easier and simpler. And, we're talking about the Supreme Court. Once you set a jurisprudence that gets further gray is added to the equation and things are remanded, it could create a lot of issues for everybody and compound the uncertainty to which Tom has spoken of. And Tom's right to be concerned about that uncertainty. I think, Tom, wouldn't you say that that's really the big driver?
Yes, absolutely. I think it is. To your question about the middle ground, I'm hearing a lot of talk about possible middle ground things like, well, maybe they'll find them unconstitutional, but they won't require the government to refund tariffs paid in the past. Or maybe they'll find the fentanyl tariffs constitutional, but the reciprocal tariffs unconstitutional. Those are some of the things I keep hearing about. Cameron, I'd love to hear your thoughts. Are those realistic? Are those possibilities? And if so, what would the ramification be if something like that, one of those options or some other option were to happen?
I think you have to start with the beginning question of what's a national emergency and who gets to define it. And just because the president says it doesn't make it so. And, there's some scholars who would say, yeah, he does get to define it. And if he does say it is, then it is. And it's one of those, this, everybody always pushes on this, King Trump or this monarch issue. You have to keep in mind that the Constitution is, not that far from a constitutional monarchy. I mean, it does have a presidential nature to it. It's one of these things that we have to look at. I think there is some middle ground, especially if you start, really looking at what is a national emergency. But I don't see the court getting into those weeds readily. I think they would be concerned about doing that. That will delay the opinion if it were to do so. And I think the court wants to get this off its plate earlier rather than later. Now, some people have said to me, well, Cameron, why do you think that? And I'm like, well, if the government has anything to say about it, I think the president would love to have a win right before the State of the Union. PR on it would be the victory lap. There's not enough oxygen in the room. It would be bigly, to say the least. If there are refunds, Tom, $130 billion getting back into the economy is quite a stimulus package. I'm not sure how that would happen exactly. I think there's lots of different avenues. I think the administration has been telegraphing, and certainly CBP's repeated discussion about electronic refunds and ACE and building out the ACE portal and ACH payment refunds and the PR piece that they've been running on it. Although I do notice they need people over there. Boy, I've been on their social media sites and there's a daily ad for help wanted in some fashion. Wow, they're just shorthanded. So I don't know how they're going to manage it and do it and get it back to people in a timely fashion, but time will tell.
That's definitely something that we're dealing with right now. Yes.
Yeah. So since we're talking about these, let's run through some scenarios, which I'm sure many of our listeners are already kind of desperately trying to do. And let's start with you, Tom. So give us, in your opinion, right, 3 outcome scenarios with A, tariffs are upheld, B, tariffs are struck down, C, there is some sort of partial limited version of it. Like, what does each mean, in your opinion, operationally for importers and brokers? And I know it's a loaded question, but let's start with you.
Yeah. Well, sure. So if the Supreme Court finds that the tariffs are constitutional, I think, like Cameron said, that will embolden the president. And I think we're going to see a far greater use of tariffs going forward. We're going to see a lot more. I would think we would see a lot more targeted tariffs going after specific issues. And I think that I'm scared about that. I think it'll make life much more complex for companies that import. But honestly, I think just about any outcome will make things more complex. So if the Supreme Court finds the tariffs unconstitutional, then everybody's going to be scrambling, trying to figure out how do we get our money back? And how do we make changes on our current and future transactions so that we're not paying the tariffs that we don't no longer owe? One of the things that we haven't touched on, but is Cameron touched on ACE, that's customs system that they use to collect the tariffs. One of the unintended consequences of these tariffs is that because they've become coming out so quickly and they're so confusing, they're so complex, is that the systems will accept just about anything. If you submit, if you or your broker files an entry with a miscalculation of the tariffs, the system isn't looking to reject it right now. It just collects it. And the government's position is the importer's got the responsibility to do it right. So we're going to be dealing with that issue as well, right? So if there's refunds, how much do you refund? Do you refund what was actually paid, or do you refund what was owed? And how do you make that calculation? So those things are going to be challenging. And if there's some type of a middle ground, I would imagine that would result in additional lawsuits, right? So in other words, let's say the Supreme Court were to come back and find that one of the tariffs, let's say the reciprocal tariffs, were unconstitutional, but the fentanyl tariffs were constitutional. I think that's going to generate more activity, maybe from Congress, to try to revoke the emergency, for example, with Canada. Is Canada really enough of a problem for the fentanyl issue for that to be considered a national emergency? And I think there's a lot of question about that. So those are some of the different things that I think we would see happening. I don't see a Supreme Court ruling, regardless of what direction it goes, simplifying the process, or at least not in the short term. I think we're going to see a far greater complexity after the Supreme Court ruling comes down, with a long tail before it settles.
Yeah, I agree with that. And I guess, Cameron, if the tariffs are struck down, would the impact be immediate in your opinion, or is there a stay or remand or administrative unwind of some kind? What would you expect to see if the tariffs are struck down?
Well, again, why are they struck down is the critical question. Just because they're struck down, as Tom mentioned, it's not necessary that they would facilitate the refunding. So the court could just simply say that these tariffs were unconstitutional, but maybe with some explanation as to why they're unconstitutional that would give more guidance. So then maybe the government from administration people could strategize about how to get around it. One of the things that seems to be a universal constant is there are more tools in the president's toolbox that would allow him to obtain similar results using different legislation. And of course, there's always Congress could just flat out pass Resolution Act or something that would facilitate, again, this collection of duties. So it really depends on, not just striking it down, but why is it struck down, and what the scope of the ruling is as to the nature of the refunds, and then the administration's reaction to that ruling, and what they put in place, countermeasures, if you will, to achieve similar results and bring their trade negotiations in a different way. I think that all of the options, and goes again back to the word uncertainty and why it's so popularized in these conversations, is we want landed cost calculations for our clients. That's what good trade strategy, good trade compliance yields. And because if you are anyone doing anything in business, you want to be able to know what your total landed cost calculation for your merchandise is, so at the point of sale, you can make a profit. Now, you do not want to be in a situation where you are guessing about your profit. No one wants to be guessing about profit. So I think that at the end of the day, we are going to see continued instability until the court rules and gives us greater guidance. And even after that ruling, we'll be dealing with the countermeasures that the administration launches in an effort to maintain their negotiating postures. That's where this is going. And we've got to get a good trading relation, a stable trading relationship with our major partners. The sooner we do it, the better off the country will be, I think, and businesses will be. After all of this gristmill is done, and I don't know if it'll ever be done, but if we could get some stability in the system within the next 12 to 24 months, we could go back to a much better trading relationship with people. And that would be good, I think, for all parties. And yes, there would be increased regulation over it, but at the same time, that regulation would be predictable and logical, and the systems, instead of being wholly reactionary, could actually be, planning, strategic, thoughtful, which I think is where people like Tom and I, that's really where we're best at, because we can see the road ahead, and that's a pitfall. Let's avoid it. Right now, we're like, the pitfall could be there, it could be there tomorrow. It's like Wile E. Coyote, going down the road. Is that a tunnel, or is it something that the Roadrunner has painted on the side that looks like a tunnel? We don't know.
Yeah, that's a good analogy for sure. So trying to get, practical, right? In the meantime, for you, Tom, and then I'll ask the same to you, Cameron. So from the trade perspective and what you are advising people these days, like what are the things that companies should be doing, or are there any things that they should be doing from the trade perspective, Tom, and then from the legal perspective, Cameron, that you're recommending people do while we hear back and end up really knowing what's what?
Well, one of the biggest unknowns that we're dealing with right now is assuming that the Supreme Court finds the tariffs unconstitutional and orders refunds. What's the process going to be? That's one of the things that companies are really struggling with right now, because we don't know the answer to that. So the process could look very different depending on what the Supreme Court says, and potentially based on what other courts say if the Supreme Court doesn't make a decision, and based on what Customs says, because they're the ones that hold the purse strings, based on what they do, and potentially even other government agencies like Treasury could weigh in. So the question right now most companies are struggling is, what do I need to do to best protect my interests so that I get all of the tariffs that I'm due back to me? And so there's a few different paths. Some companies are simply assuming that there's going to be a refund process and that everybody will get their refunds, and that they will simply maybe have to fill out some forms or do something, but they'll just simply get the money back. I think that's not the wisest course to do, because we don't know for sure that there will be tariffs automatically refunded. So there's a couple of paths that many companies are taking that I'm recommending to clients. And one is going through what we call the protest path. And so with that, one of the ways to get refunds normally from Customs is by filing a protest. And what that is, it's an administrative process where companies can basically say to the government, we misapplied the tariffs, please refund the balance. But there's some procedural steps to that. First of all, the entry has to liquidate, which generally happens around 10 months after the goods are released by Customs. And then at that point, a company can file the protest, and they have a 180-day window from that point to file the protest. So we're talking about anywhere between 10 and 16 months after the goods are released, a company can file a protest and basically provide Customs with a formal claim for refunds in the event the tariffs are found unconstitutional by the Supreme Court. And a lot of companies are doing that, and I'm recommending to clients to do that. Now, there's another path that many companies are taking, and Costco was one of the ones that was most noteworthy. That was one of the biggest names of companies that did this. And that is, they filed a lawsuit in the Court of International Trade, where their basic argument is, we feel that we should not have paid the tariffs, and we feel there may need to be a legal path that we go through to get refunds. So we're going to file a lawsuit. And these lawsuits are basically being suspended pending the decision by the Supreme Court. And so the argument is, maybe that's the path that we need to go down. Now, that path generally has about a 2-year window before the case must be filed. But what's not clear is, when does that 2-year window start? Is it when the tariffs were first imposed? Is it when I first paid the tariffs, or is it another date? And so again, some companies are filing lawsuits. Some companies are filing lawsuits and protests. And some are just getting ready and watching. And I think the biggest recommendation that I'm making right now to companies is monitor this stuff. Cameron mentioned ACE. Companies can get it. Any company that imports can sign up for a free ACE web portal account, and they should. And they can run reports that'll show where their entries are at in that status and how much they've paid. And they should be able to use that to determine how much they'll get back, depending on the decision of the Supreme Court.
That last point is, I think, universal.
Yeah.
Is that you have to have your documentation ready, organized, reports. You got to have working with your broker, working with an ACE account, gathering the documentation to identify what entry was filed on what date, how much IEEPA duty did I pay, how much 232 duty did I pay on, and so on, and did it or did it not liquidate? That's critical data points that anybody who's importing needs to have that as a baseline.
Yeah.
I would also say that you have to look to what you can control. And at the moment, there's a lot that's beyond, the moment. What do we actually know, and should we prepare for it or should we not? And how do we do that? But things like evaluating your supply chain and knowing who you're doing business with, identifying commodities that might be transshipped, identifying things that might be assembled one place, claimed to be the country of origin of another. This is something that if you have a particular SKU that is a particular value and has a very high percentage of your total duties paid, is worth examining to make sure that you are not going to get a surprise about, gee, not only, and I mention this because there's a presidential proclamation dealing with transshipment that assesses 40% additional duties on top of the assessed duties. So this is on top of reciprocals. It's just an enhancement. Think of it as like a hate crime. Lots of things that people do are against the law and subject to punitive, if you assault somebody, etc. But if you do it because of a particular reason, because of a racial reason or a religious reason, that is an enhancement. So this is transshipment is a 40% enhancement, and it's non-mitigatable. It straight up says in the presidential proclamation, it cannot be mitigated. And so what you have to look at is my supply chain vulnerable to this? Who is managing this for me? And will the government be using other statutes to enforce it? One of the things I noticed in a CTPAT publication in December, and has been echoed by the administration, is that transshipment's always been illegal. Well, transshipment is circumvention and evasion, according to this administration, because they just use those words. They talk. The word thing drives lawyers crazy, because usually words have meaning, and we use certain words in certain contexts to mean things. And when you just use them interchangeably in any publication or discussion, you get on Truth Social, and you just start using these words, just whatever. It really makes people anxious in my world, because you're like, are you creating a whole new species of duty that's based on transshipment in and of itself? And if that is true, it goes beyond you misdeclared it at the time you entered it. You are now in violation of 1592. All right, fine. That's one version of this. Or now, do you have additional enhancement, 40% on top of it? And if the government had to do something to the carrier that carried it, because there has been citation to a case law or a statute, excuse me, where there was a seizure of the vessel. Now, I can say that this is very isolated. It's prohibition era stuff. And maybe the government is just kind of putting this out without really thinking it through, which wouldn't be the first time. But you tell me that you're going to prosecute people under a prohibition era statute where you're arresting and forfeiting vessels. That has a whole additional contractual implication, because if you start arresting an MSC vessel and delaying it because of alleged transshipments that you were engaged in, and then they get to suffer because of it, I'm here to tell you that they're going to. You thought demurrage was a punitive. Vessel demurrage is a whole nother level. That's, container demurrage is one, thousands of dollars a day. It's a lot of money. But we're talking about hundreds of thousands, if not millions of dollars a day for vessel arrest. So, and contractually, you have an exposure as a cargo owner if you are placing these things onto the vessel. You just do. You have to indemnify the ocean carrier. So what I'm looking at is not just the basic, and they're not basic, by the way. I mean, the very convoluted tariff issues and the very convoluted cost issues that arise as a result. But also, let's play a little chess and look at what's going on if a vessel operator or a terminal operator or others are involved in all of this, and what your contractual obligations as a merchant under those contracts can basically come back to haunt you. So now all of a sudden you're looking at millions of dollars of exposure. I was involved in a case 3 years ago where there was a forced labor allegation made. 202 ocean freight containers sat at the port of Los Angeles, Long Beach. There were millions of dollars of demurrage that accrued because of that. So while there was a clear and obvious forced labor issue and clear and obvious, problem with importing those goods, there's a whole other backside of it that people don't really appreciate. Like, what happens to those goods that sit there? And I've got 10 containers of honey that have been sitting in New Jersey for a year and a half. And I'm fighting with Yang Ming and Wan Hai about what to do with that and who's going to be paying the price, because the importer is not doing anything, because they're in a kerfuffle with customs about, is it or is it not Chinese honey? They've been fighting about it for a year and a half, but everybody, meanwhile, the meter is running on these containers. And there's now millions of dollars of demurrage. Who is going to pay for it? And is it even right to assess it to begin with?
Yeah.
So these are the other risks that are out there beyond these tariffs. And to Tom's point about this, surprise, his comment about, you wake up today and all of a sudden the cargo that you bought for $1 is now worthless because it's subject to $2 worth of duty. You're not going to import that, are you? You're just going to abandon it, especially if you're a small operator and you don't have the money to pay the duty. Small businesses get hit the hardest. The consumer doesn't know what the pricing is going to be, whether you're talking about the business consumer, Joe and Mary down at the supermarket. So all of these things have to be seen as part of the same system. This is the ecosystem that we live in, and you got to be playing chess, not checkers. And that's why you need, if anything, there's in the Wall Street Journal this morning, apparently trade compliance and consultant folks are in demand, Tom. So we're good.
Yep. People that understand
And,
tariff are high demand today. Yes.
And I mean, I know we could go on for hours, right? And there's so much to unpack with this. But as we wrap up, here, and just kind of doing a quick lightning round, I guess I'll ask, starting with you, Cameron, one prediction, one misconception, and one practical takeaway for our listeners.
Well, I think that all of those can be answered simply by saying you have to not listen to the noise, not listen to what is on Truth Social, not listen to what's in the media, but look to the people who are competent to advise you and have them give you as much solid ground as you can move forward on. The best advice here is really to look to what you can identify in your supply chain and how you can shift it to best achieve your goals. And is nearshoring the right thing? Is sourcing domestically the right thing? Is buying on DDP the right thing? These are options, and you need to talk to people who can really help you. So I think that's where I think this is all going. The more you know, the less risk you have. And to not just look internally, but externally, and look to insurance products as well and other contractual risk shifting tools, because the more you spread the risk, the better off you are. So I hope that
Yeah, it's very
satisfies.
good advice. Yeah, it's very good advice. And you, Tom, any one prediction, one misconception, one practical takeaway?
Well, the prediction that I'm going to make is that whichever way the Supreme Court decides on the case, things are going to become more complicated. Things are going to become far more complicated regardless of which way the Supreme Court decides. The misconception is that if the Supreme Court does find the tariffs unconstitutional, that money will flow back quickly and easily. That's just not the case. As far as advice, I think the primary advice that I give to companies is just know your data, understand your data, know what it is that you've imported, know how much you've paid in tariffs, know all of that data. The data is available to you. Have it at your fingertips so that you can make better decisions as news comes out.
This is great. Guys, thank you so much. Cameron, what a pleasure. I know that our listeners will benefit greatly from your comments and advice. If they have any questions, where can they reach you?
Well, they can reach us at tradeandcargo.com, their website. Used to be able to Google me and I would come up pretty early, but unfortunately there's a much younger, much more handsome actor who's taken the first 10 slots in Google. But we're here in Los Angeles, Redondo Beach, and Houston, Texas. We have offices, and we're happy to help any way we can.
This has been awesome for everybody. Don't forget, go check Cameron's podcast, and we'll be back in about a month. In the meantime, thank you so much for your time, and we'll speak again soon.